dog to come in. And when I watched Reluctant Prophet, he was covering a Lane Myers live stream and talking over most of it because he's fucking inept. And one of the things he started talking about was some proposed modification to the Arizona Supreme Court rules or something like that was introduced by the husband of the victim. And I guess he was trying to get everybody and their dog to come in and say that they were not in favor of it. But that also is not a democratic process. The purpose of that process was to allow people to make arguments as to why that particular rule should or should not be enacted. And so the Supreme Court can look at the arguments that are made and see what arguments are good and what arguments are not so good, so they can follow up on whatever, so they could have a better informed decision. Just like in most hearings, you'll have an attorney on one side make an argument and the attorney on the other side make an argument, and then the court will determine which argument is the best. And once again, it's not about a democracy, it's about who has the best argument. That's what they were looking for in the rule modification, public, making that open to the public for comment. That's what they're looking for, is the best argument, not the most arguments, but the best argument.
I mean, if you want to look at it that way, I guess, but it's a petition to change a rule. Don't petitions normally need like multiple people supporting them before they're even considered to be legit? You know what I mean? Wouldn't the number of people have something to do with that? And I don't know if you read any of them, but some of these arguments made by these people are absolutely golden. You know what I mean? And here's how weird this whole thing is because his wife's situation directly relates to his wannabe rule change. You know what I mean? Like, harassment of the victim, like live streaming is harassing in some way. You know what I mean? It's only harassing because he had his wife go fill out an injunction for harassment with him advising. He was there the whole time, beginning to end, both times, the fake one and the other fake one. You know what I mean? And also too was being advised by the APAC, of which she is a counsel advisor to, using the you just can't see it, bro. It's hard to explain. Look, she is the APAC, Arizona Prosecuting Attorneys Advisory Council, right? She is the director of alumni and development, right? His wife. And this lady, Elizabeth Burton Ortiz, is the APAC's, whatever you call it, executive director, right? Okay. She is in support of Matt Walker's petition for the rule change. Now, look at these curious dates that have been set for these meetings. Now, I just want to take time out real quick to highlight one of the things this lady said from the APAC, this Burton lady or whatever. She says, as detailed in the petition, defendant used a smartphone to broadcast live stream the proceedings to his YouTube channel. No, he live streamed it to the world. Now, after only giving notice to the court, in so doing, following the rules as they are, the defendant effectively targeted and amplified his harassment towards numerous participants in the proceeding. Right? Okay, think about that. He live streamed it to the world, and by following the rules, he targeted specific people for harassment. Now, his conduct wasn't harassment in court. They did nothing about it in court, right? But she's saying that it's targeted other people to harass the people in court. She just explained what constitutionally protected speech is. According to the 2004 State v. Brown that they keep reciting over and over. In deciding whether a particular conduct possesses sufficient communicative element to bring the First Amendment into play, the Supreme Court asked whether intent to convey a particularized message was present and whether the likelihood was great the message would be understood by those who viewed it. Some examples of expressive conduct found contain a particularized message are burning of the flag and the protesters at the National Convention, C. Johnson, blah, blah, blah. The wearing of black armbands to protest the Vietnam War, and the sit-in by African persons against library segregation policies. In all cases where a particularized message has been found expressive conduct, there was little doubt from the circumstances of the conduct that it formed a clear and particularized political or social message very much understood by those who viewed it. Young v. blah, 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 blah. So if people's reaction to hearing the exact same recording the court has that Mr. Myers released, if people's reaction is to call the court and talk shit, well then guess what? That is a particularized message very much understood by those who viewed it. Unethical prosecutor, calling the unethical prosecutor an unethical prosecutor and saying that his wife's a cunt, like the circumstances surrounding that, it were pretty much understood by everybody, obviously. By this lady's statement, she's saying that his speech is constitutionally protected. The conduct arising from his speech. Now, what's happening is this, ever since he got embarrassed, and then the APAC held that meeting on the 10th, right? Then look at their next meeting. I'm sorry, the previous meeting, September 12th. That's weird. So they had a meeting on the day his harassment started, and then they had one on the 10th, the day she filled out the injunction for harassment under the supervision of Matt Walker, the one who's trying to amend this rule. And then every hearing after that, every single judge questions the rule and makes it a big deal. Come on, dude.
Myers, is that correct?
Yes, sir.
If you could confirm your date of birth.
October 15th, 1982.
And an address at which you received mail. Thank you. That's a house, no unit or apartment number?
House.
All right. We also have then an email address of
And I will put for the record that I do appreciate, so yesterday somebody tried to call me to tell me how it got switched, and they kept saying, wait, they wanted me to wait on the phone until the email went through, but it never came through. As of right now, I never got the emails. She said she sent it 3 times, but as we stand here, I mean, I knew it was gonna be a quick turnaround because I wanted that, so I came here in person and got this, but the email from the clerk or whatever that you said in here, it never came. As of right now, it still hasn't came, and they said they sent it 3 times. Confirm the email and all that. And I get other emails from other cases.
All right, thanks for letting us know. We'll look into that on our end. And then, sir, have you ever served in the U.S. Armed Forces?
No, sir.
And next, I must inform you, the state of Arizona has charged you with a violation of the law. Specifically, they've alleged you violated Arizona Revised Statute Title 13, Section 2810, subsection A2. That's interfering with judicial proceedings, failure to comply with the court order. It's a Class 1 misdemeanor, maximum possible penalty, $2,500 fine, plus additional surcharges up to 6 months in jail, 3 years probation. I don't know if the state will seek the maximum penalty. That is the maximum allowed by law. Because you've been charged with that Class 1 misdemeanor, you'd have to receive prior permission from the court before you leave the state of Arizona. But before we go any further, I do want to review some of your constitutional rights, okay?
Please do, because they're important.
So you have the right to plead not guilty, and I'll enter a not guilty plea on your behalf at this time.
Thank you.
You also have the right to a trial, and you have the right to the assistance of an attorney at all court proceedings. You further have the right to remain silent, and you are currently presumed to be innocent, unless or until the state can prove your guilt beyond a reasonable doubt. And even then, even if found guilty at trial, you would still have a right to an appeal. However, you would lose that right to an appeal if you were to cause your own sentencing to be delayed more than 90 days past any conviction. Now, you further have the right and the responsibility to be present for all future court proceedings. You fail to appear for any court hearing, a couple things could happen. First is that the proceeding could be held in your absence, including even the trial. Second thing that could happen is that a warrant would issue for your arrest. You'd be charged warrant fees. Could be charged with another misdemeanor offense called failure to appear. So it is your responsibility to keep your current address and contact info updated with the court. That's how we'll let you know what's going on in your case and when your next court date is. So as I indicated, you do have a right to an attorney. In some cases, you'd have the right for the court to appoint you one, but only if the state is seeking to deprive you of your liberty.
Right.
So this time I'm going to ask the state prosecutor. Ms. Walker, the state seeking jail or supervised probation in this matter?
Yes, Your Honor.
It is?
Yes, Your Honor.
All right. And so, sir, again, I noticed you had filed the notice of appearance that you would like to proceed pro se. Of course, since the state is seeking to potentially deprive you of your liberty, you are entitled to.
They've already done that, actually,
So,
by charging me.
so again, that would
I
not-
drove past the. Will I be arrested on my way out because I drove past 30 feet past the law school down Speedway today? We need to get to the constitutional issue of these charges. We can't even arraign me without probable
Your
cause.
Honor, I would implore you to.
I would implore her to not interrupt.
Again,
Is she objecting or is she talking over me?
Yeah, so we can't have people talking over each other because we are recording.
It's my
everything.
turn to talk.
Right, and so then Mr.
So I drove
Myers,
past 30 feet on the way there, and I'm gonna drive past 60 feet on the way home. Will I be charged? Yes or no?
So, Mr. Myers.
I'm charged with being 150 feet from a protected location in a moving vehicle. So will I be charged on the way home because I drove past on the way here and home? I'm gonna drive past the same location that you're arraigning me for and make a mockery of this whole fucking thing.
Right, and so Mr. Myers, one, will not use profanity in the court. We will maintain judicial decorum
It's all
in the
good, bro.
courthouse. The second thing is, as a judicial officer, I cannot provide you legal advice. Third thing is, I don't know what the facts of the case are. I need to remain.
We're gonna have an evidentiary hearing next week. Please set one.
All right, so Mr. Myers, again, I don't have any requests in front of me.
Okay, I'll put one in. I'm requesting one verbally, verbal motion.
And so, Mr. Myers, just as I gave you a turn to talk,
Right.
you
Oh, go ahead.
will not speak over the court because, again, we are recording everything. All right, so like I said, I can't provide you legal advice. I don't know what the facts of the case are. So I have formally arraigned you here in the matter. Again, the state was seeking to deprive you of your liberty. You are entitled to an attorney as a matter of right. However, I noticed you filed the notice of appearance saying you'd like to proceed pro se. I just want to make a clear record. You would not like the court to appoint you any counsel.
I don't need a kangaroo. I don't need one of your fake kangaroo attorneys, no.
Right, and so again, Mr. Myers, if we can maintain decorum in the courtroom.
Like you said, you had 9 years experience when you had 3. My wife actually trained you.
Okay, I don't know what you're referring to, Mr. Myers, but again, we're going to maintain decorum here in the courtroom. So I am your assigned judge. Our next court date, we already set for that status conference on December 5th. Mr. Myers, any other questions or concerns?
Oh yeah, big time.
Here today?
For sure. I want to move the motion to compel production as of November 5th. So they like to play games. We have another case 5 months in. They still haven't turned over the evidence. I'm going to tell you right now, Your Honor, I'll file a motion to compel under 15-7 every single day in this case. Because I can tell you right now, the police officers have the police reports. I don't have them, okay? A local reporter went and got the police reports, but I don't have them. I've put in a request for them. I've put in requests for pretrial interviews. I haven't even got a response. Nothing. They didn't properly serve me. Her motions don't meet the rules under 1.6. They're supposed to be 12. 13 font, they're 12. They're not formatted properly. Her headlines aren't underlined. They're not italicized. She doesn't even know how to format a motion. The motion that came in the mail, you should have stricken it because it didn't meet 1.6 or 1.9. It wasn't formatted properly. So then the next one that came, you know, I don't want to nitpick because you actually granted it, but if she can't put the proper font, she can't file the motions. That's like literally Arizona Rule of Criminal Procedure 1.6b. So the issue now we move to is disclosure. We're sitting here when I know for a fact under Rule 15.1, they're required to turn this over, but they've been dragging their feet because as of on November 5th, a local reporter got all this case information, but I put in a request on October 25th. So the defendant in the case requested it on October 25th, still doesn't have it, but a local reporter requested it on November 5th and got it the same day. But I don't have it.
So again, Mr. Myers, I don't know what you're talking about because I don't have any written form.
I did put it
in front of me.
I did put a request for disclosure in. And I gave it to her and it was properly served.
Right,
And you don't have to do certificate of service in a lower court.
Right.
You know, and I told her how to serve me. And they sent me an envelope in the mail with their motion and the minute order from your order. That's not how we're doing service in the court, okay? They have my email. We have another case going on. They're seeking jail time because I booed at City Hall, not because of this. This is a mockery, sir.
Jail time on that case.
Huh?
I'm not seeking jail time on that case. Please don't mistake the facts.
No, you're seeking it in this case to get it out of that, to try to cover up what you're doing in that case. You're a clown, plain and simple. Are we done here? So you want motion to compels? Because I know judges hate motion to compels. Because I'm gonna file one every day. Where's the disclosure? It's been so.
Again, Mr. Myers, you've asked a litany of questions here.
I gotta talk fast before I get arrested.
Your Honor, may I be heard?
Yes, Ms. Walker?
Thank you, Your Honor. The first thing that I would like to address is to inquire if Mr. Myers is live streaming, broadcasting, or recording this hearing, as well as any of the multiple observers who are online. The reason that I ask this is because Mr. Myers has historically recorded without permission, as well as broadcast information without the court's permission.
Objection, Your Honor, irrelevant. I got permission. This is the gaslighting that they want me to get me pissed off and arrested at for today.
Your Honor?
So, Ms. Myers.
She doesn't even know the rule. 122H,
Mr. Myers.
broadcast is not coverage.
Right, again, Mr. Myers.
Just tell her to be quiet then.
We'll maintain decorum, again.
I just dealt with this yesterday with the same thing in a different hearing yesterday with this
Your
bullshit
Honor,
with her.
at this point, I would ask that you hold Mr. Lane Myers in contempt
Myers.
to obey the court's orders.
Again, I'm going to remind you, we're not to use profanity here in the courtroom.
Actually, it's my First Amendment right to use profanity. I get what you're saying though. I'll be decorum. Like we can find a line between me using the words and the words you don't find acceptable and what I might want to say that isn't traditionally what's said. I don't need to use every profanity, but if I drop one once in a, that's just who I am. Hold my disability against me, I guess.
So again, Mr. Myers, there's been no filing of any ADA accommodation.
No, I'm
request.
going by what they say. They say I'm disabled. I'm not.
Right, and so again.
I'm crazy, I'm disabled, I'm mental, I'm a domestic terrorist.
Right,
They got a wanted poster for me. So let her tell her thing how I can't record under a Supreme Court rule because it hurts her feelings while other people are doing it. While the whole case, look at Shannon Walker, a victim, is doing it, right? She's allowed to watch, but why can't other people?
Your Honor, if I may be
So
heard.
the record will reflect the presence of the victim appearing remotely.
There's no victim in this case. There's a victim, there's no victim. So that's what I'm saying. Why does it say victim? This was a civil injunction that's a plaintiff and a defendant.
Right, so Mr. Myers.
So in this case, when you violate the court order, there's no victim. I didn't talk to her. I violated it by driving past the building. There is no victim in this case.
Right, again, Mr. Myers, I don't know what the facts of this case are.
Why does it say victim?
I'm going to turn to Ms. Walker for some clarification. Ms. Walker.
Thank you, Your Honor. Mr. Myers has been charged with interfering with judicial proceedings, failure to abide by a court order. The alleged victim is Shannon Walker, the holder of that court order, the injunction against harassment. We won't go into the facts of the case, as this is not
we'll go into
either an evidentiary hearing nor a bench trial. I would also like to revisit Rule 122.
H.
I would also, Your Honor,
Right,
I
Mr.
would ask
Myers,
that you not interrupt
just
me.
as we gave you the opportunity to speak, we're now going to give Ms. Walker the opportunity. So
Is
Ms.
my
Walker-
presence required here still?
Yes.
Yes, it is, Mr. Myers.
For what?
Because we're in the middle of a legal proceeding.
All right.
Ms. Walker.
Thank you. Your Honor, under Supreme Court Rule 122, a person must request to record or broadcast.
Except as provided in subsection
Mr.
H.
Myers.
This is wasting our time.
Mr. Myers, your interruption, again, is interfering with a legal proceeding. Ms. Walker, please continue.
Thank you, Your Honor. Under 122H, as Mr. Myers states, it does authorize the use of a personal audio recorder. First, he must put in a notice of using that personal audio recorder. None of that has been used.
Actually, I did. You're wrong. I did it before you got here. So you're fucking gaslighting us.
Mr. Myers, please do not use profanity in the courtroom. And also, the parties are directed to speak to the court, not to each other. So, Ms. Walker, Mr. Myers is correct. He did provide notice that he is recording with a personal device pursuant to Supreme Court Rule 122, subsection H.
Thank you. The rule that I would clarify then, Your Honor, is he recording? And I would just like to clarify that. And also, any observers must also put in that notice or a request. None of those are present here, so I would implore the court to ask the gallery if any of them are recording.
Shannon Walker, the victim, that's the gallery.
Right, so again, Mr. Myers, we can't just speak whenever we want here in the court proceeding. So I will note that Ms. Walker is correct. There has been no request to record the broadcast, to record the court proceedings. So I want to remind all those observing that you are not to be recording these proceedings. It would be in violation of the Supreme Court rules. So anything further at this time, Ms. Walker?
Yes, Your Honor, I'd like to address, I do have initial disclosure here with me. We've also put in a request for media. All of that will be making its way over to Mr. Myers. We do have his email. We will be sending that shortly. If you would like to ask for any kind of evidentiary hearing, I would ask that substantive motions be filed as is required so that I may respond to them. So at this time, that was just me clarifying the record. I would also just ask in the future, I understand the urgency of needing to set this hearing, but there is a victim in the case. She's been watching me very closely, and that's how she caught that there's the hearing today. I actually didn't even know that this got set today.
Really? She was watching it very closely? Is that what it was? Or is it because the APAC is hosting communications between the attorneys.
She could have requested.
So again, Mr. Myers, I'll give you another opportunity to speak. Right now, it's Ms. Walker's turn. Thank you.
So just moving forward, I would request, I'd also like to confirm that Mr. Myers is not live streaming. That is a major concern with this case, and that he is in fact just using a recording app rather than any kind of phone or live stream.
Read 122H, sir. It says broadcast on person. It defines in 122H cover and coverage. We can play games. I'm not stopping.
Your Honor, that seems to give me the impression that he is in fact live streaming or broadcasting this, and
Broadcasting under 122H,
Right, again,
audio only.
Right, again,
So are
I'll
you.
allow you an opportunity
Right, so are
to
you.
respond.
You're broadcasting under 122H also.
Your Honor, if I may just clarify, and I do have the rule with me.
Me too, in my head.
A person may use a personal audio recorder during a proceeding, but the person must notify the judge and the judge's staff prior to using the device.
I did.
A person, and actually that does have a timeline, Your Honor, of I believe it's 2 days.
No, it doesn't. You can literally do it when you walk in the courtroom.
Mr. Myers, again,
And-
I'll allow you a proper opportunity to respond, but we cannot interrupt.
And
Walker.
a person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of the proceeding with a device that is not on the person must do so. The use of a personal audio recorder must not be obtrusive, distracting, or otherwise prohibited, and use is subject to prohibitions of paragraph K of this rule. Your Honor, this case is, as you might already tell, a rather high media case given Mr. Myers' online following. This case in particular regards an injunction against harassment given his streaming, as well as any other context that he has
Allegedly.
with Ms. Walker, Ms. Shannon Walker, the victim.
From a victim to alleged victim to the victim, all in one hearing. Right? Dude, this is all for the 122 show, dude. This is all for the same reason. The APEC got together and said, hey, y'all want people to stop fucking recording in your courtrooms? Make a big deal out of this shit and call Shannon the victim. Right? That's what they did. And it's all part of the plan. So Shannon Walker is part of the APAC, which is the director of the board is Elizabeth Burton, who is in 100% support of Matt Walker's 122H petition amendment thing right here. She's in support of it. And she's the one who convenes these board meetings or whatever. Executive director directs these facilitating meetings where they're just so happen to be on days that Mr. Myers harassed somebody. Recorded by S. Morgan, Smorgan, right, who also is down with the 122H sting by Matt Walker, the husband of the person that's the victim, that's the alleged victim, that's not the victim, that is the victim, that might be the victim, that became a victim in 7 minutes. Give me a fucking break. You guys are retarded. Now read this again and tell me if you guys think there's still a problem. Oh, this is the conflict of interest statute.
So for these reasons, I would implore the court to not permit any kind of broadcast. And I would again ask if he is in fact live streaming and broadcasting this proceeding.
Thank you, Ms. Walker. Mr. Myers, if you wouldn't mind from the microphone.
You claim this is a high media case, right? Well, because of Mr. Myers' following, well, he only has 15,000 followers. This got 38,000 views, you know what I'm saying? When the court decided to broadcast it. It gets more views from the court than it ever did from Lane Myers. It's broadcast to the world, not to just his followers or the court's followers. It's broadcast to the world. Now, just some random shit that I question or,
in Jackson County.
You know,
For protection.
Whatever.
I'm going to open your file up and see what we can tell you, Mr. Oliver.
Is there any way I can be provided with a copy of the affidavit?
Yes, sir. Yes, sir. In order to do that, you have to participate in the discovery process, which is the first thing an attorney would do if you're represented by an attorney. If you represent yourself, you've got to file certain paperwork saying that you want to participate in the discovery process.
Yes, sir.
But it obligates you to do certain things also.
Okay. File motions, etc.
It obligates you to provide a witness list.
All right.
So what the complaint says is someone named Rachel Tanner, who received a call from her goddaughter, Ashante Moore, saying that Ashante, you had, I guess there must be an injunction.
Can I stop before you go any further, sir, and waste your time? I don't have an injunction against me in Jackson County. So how did I violate an injunction?
Is there an injunction against you in Florida?
Yes, sir, it is.
It doesn't matter if it's in Jackson County or not.
But I never had any contact with the person that the injunction was on, nor did I speak upon this person when anything occurred. Okay, by law, when you have an injunction against someone and it's third-party contact, it would be equivalent of me saying, hey, Judge Mercer, would you tell the person that has an injunction on me, this, that, and the third? If I see you and you're someone or have some type of relationship with this person, you just can't call the police on me and say, hey, he seen me and cussed me out, and you have an injunction on him, call the police. I read the affidavit off the internet. And what that's saying, I shouldn't even be standing right here.
Who is the injunction? Is it against Moore or is it against?
I have an injunction against Rachel Tanner. She lives in Panama City, Bay County, Florida. The injunction is in Bay County. Basically, from what the affidavit is saying, me and her goddaughter got into it. She called the person that the injunction is on to have them call the police on me and come down here. I never once said her name. She didn't say I said her name. She didn't say I mentioned my baby mother. She just said me and him got into an altercation. Call you, and you call the police. That ain't legal. That shouldn't even be legal.
Ashante stated Kurt was my question. Basically, okay, so you had an attorney representing you. So you've seen the trial process.
Yes, sir.
And you're adamant that you want to represent yourself, which is your constitutional right.
Yes, sir.
Here's what I have to tell you. This is what I tell people. What do you do for a living, Mr. Oliver?
I work here for the Panama City.
Okay, Mr. Oliver, if I showed up at your job, what time do you go to work tomorrow?
I'm supposed to be at work right now.
What time do you go to work tomorrow?
6 o'clock.
If I showed up at 6 o'clock tomorrow to try to do your job, I will make an absolute mess of it. Why? I don't know what you do. I don't know how to do it. I don't have your skills. I don't have your training. I can't do it. What you're telling me is that you think, because you've been through a trial, that you know everything about picking a trial and that you can do just as good a job or better than an attorney who's been to law school for 3 years, college for 4 years, taken and passed the Florida bar. I have to discourage you from doing that.
Me being honest with you, Judge Mercer, you probably don't even remember me for real.
I remember the name.
I just beat Bay County last November on this same type of stuff because my baby mama keep doing this.
The complaint says you went to prison.
I went to prison. I'm gonna be honest with you. I went to prison. Right here, you sentenced me for aggravated battery with a deadly weapon.
Involving the same people?
No.
Okay.
So
it had nothing to do with it.
It's a situation where these women are keep calling the police on me, making allegations, and the police officers, nor the state attorneys, are doing their jobs correctly to identify this. It's several lies in this affidavit. You can pull up what I went to prison for right here. I went to prison at this courtroom. I've never been to prison for violation of an injunction.
So when the complaint says that, that's not correct.
None of that is correct.
So let me ask this question. You've heard me encourage you to take an attorney, represent you,
Yes,
and
sir.
you still want to represent yourself.
Yes, sir.
All right. So having asked those questions, Mr. Oliver is certainly intelligent, and he's been through the court system. He's capable of representing himself and exercising his constitutional right to do so. Is the state ready for trial?
Yes, we are, Your Honor.
Okay, when are you ready to go to trial? We have a trial period this month. That is the 26th of September.
Yes, Your Honor.
You want to go ahead and get it over with, Mr.
September
Oliver?
26th, yes, sir, when we're doing jury selection. 25th
26th will be jury selection
and trial.
and trial.
Yes, sir.
So we're going to give you a notice for September 26th, Mr. Oliver. I would encourage you to consult with an attorney between now and then. If you change your mind, your attorney will file some paperwork saying that they're going to be involved. Otherwise, you need to be here
Honestly,
September
can I get
26th.
a little bit more time? Can I maybe have this trial date maybe like around 40? I'm sorry, sweetie. Can I maybe like a 45-day period? Because that's not even 30 days for me enough to prepare. And I just found out about this last week.
We have September 26th, and then the next one after that is October 23rd.
That's good.
Ms. Bremer,
No objection, Your Honor.
October 23rd.
Holy crap. That took 2.2 seconds. So, evidence relating to a victim's reputation for chastity and opinion evidence related to a victim's chastity are not admissible in any prosecution for any offense in this section, whatever. Evidence of specific instances of victims' prior sexual conduct may be admitted only if a judge finds the evidence is relevant and is material to a fact in issue in the case, and that the inflammatory or prejudicial nature outweighs the probative value of the evidence, and if the evidence is one of the following. See, this is where I have the problem, because she offered this up in the form of a voicemail from somebody else saying like, oh, did you cheat on Matt or whatever? You know what I mean? But it's accepted for the fact that it's connects the videos to him and the police report, yet none of those things exist because she knew it was a typo, right? So how is she allowed to introduce that as evidence of anything? All it does is just, the only thing it can possibly do is poison the jury pool, which they are broadcasting to everybody. You know what I mean? Like, and because she allowed the cop to get up there and say, oh, it was a typo, then now none of it can be used as evidence of any of these things that could possibly help. And that's a must shall have. It has to be that, and the judge makes a decision of the probative or whatever, and one of these, you know what I mean? But it can't be any of these because the cop got up there and said, oh, it must have been a typo. Here's another one that's dumbfounding to me. Speedy trial. To have a speedy public trial by an impartial jury of the county in which the offense is alleged to have been committed. Okay? Well, the alleged offense is these videos that supposedly made people call, right? Well, the call is the offense, right? The voicemail is the harassment, right? These people, we don't know where they're from. And the county that it was committed, when he posted the video, it posted to the world, to every county in the world. And literally every caller is from all different counties, right? So how could they possibly pick a jury in every single county in the world? If the offense is the videos and the posting of the videos, and maybe not, maybe the offense is the call, right? An act of harassment is the actual act of calling, right? Or reaching out, you know what I mean? All that was done in different counties. So how could they possibly pick a jury? How could she have possibly thought that even if they did get a jury, that it would be fair under those circumstances? So this is mind-blowing as fuck. The summons says, please serve at the listed address, no attorney addressed, and do not forward to the public defender. So they specifically wanted him to get this and not have any public defender know about it, right? Okay. 14th day, summoned to be there on the 14th, and then...
Here in the court. I'll add it.
Let's go on the record. State of Arizona versus Lane Jeffrey Myers, CR 2025-1060.
Rachel Siles for the state. Your Honor, the victim is present.
This is William Parvin. I've been appointed to represent Mr. Myers. However, Mr. Myers would like to file a motion to represent himself. He's not sure exactly where to file that. If he can file it in this court today or if he has to go downstairs.
How is Mr. Parvin just self-appointed before the court even appoints him?
Okay, good afternoon, Mr. Myers.
Good afternoon, ma'am.
This is the time set for your arraignment. We're going to proceed with your arraignment first, and then I'll talk to you about your motion. So is your true name Lane Jeffrey Myers?
You want me to sit down?
You can still.
You can be seated.
Yes, ma'am.
Okay. On the document there in front of you that your attorney has is the criminal charges filed against you. We are going to enter pleas of not guilty on your behalf. I am going to appoint OPAC attorney William Parvin to represent you for now. I'm going to assess $400 in attorney's fees.
Right there. $400 in attorney's fees. She just assessed it right off the rip, dude. And when they could have notified him or the attorneys when they first sent him the summons, which is now in an envelope. And anyway, it's just weird, dude. And then so I started thinking about the attorney's fees. Like, obviously they do things in the order they want to do them for the reason they want to do them, right? Intensive probation. It means a program established pursuant to this chapter of highly structured and closely supervised probation that emphasizes individualized intervention for a person who is deemed appropriate for the program pursuant to section 13, blah, 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 subsection B. Includes the payment of restitution if applicable, and required pursuant to this section, subsection F, paragraph 2. So, paying probation fees not less than $75 after determining the inability of the offender to pay the fees. The court assesses a lesser fee. Probation fees shall be deposited in the Adult Probation Services Fund established, blah, blah, blah. Any amount assessed pursuant to this paragraph shall be used in supplement monies for the salaries of the adult probation and surveillance officers of the support program and devices of Superior Court Adult Probation Departments. Here's where it gets fucked up. For the purposes of subsection B of this section, a prosecution is commenced when an indictment, information, or complaint is filed. They can issue a writ of whatever. The amount due to the victim or court, clerk of the court, or prosecuting attorney as the date on which the writ is issued. The name and address of the garnishee, the garnishee's authorized agent, the name and address of the victim of the court or the court clerk. The name and address, the garnishee of the garnishee's authorized agent, the name and address of blah, 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 the last known mailing address of the defendant, the victim, or the court of the court's prosecuting attorney shall serve the following on the garnishee. 2 copies, blah, 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 criminal restitution order, blah, blah, blah. And this is all, like, it says on the defendant, right? It's not even saying on the, convicted. It's saying on the defendant. Like this happens during the prosecution, right? And if you're in jail, think about it. They serve the writ on him. He doesn't get it because he's in jail, and then he can't pay it because he's in jail, doesn't know about it, and they can convict him on that. That can be a conviction. Dude, this is so bad. And think about it. Parvin is he's the one that's owed the $400, right? You know what I'm saying? I don't know, man.
He directed it specifically at Shannon Walker by putting up her information. So he's then calling on his followers to reach out to her, because this is something he's had the history of doing this, of repeatedly putting up these videos for Shannon Walker, and for Shannon Walker, and for Shannon Walker, and